This data visualization shows the scale of the annual financial loss facing the Indian entertainment industry. Rampant digital piracy removes roughly $2.7 billion from the sector every year, resulting in an estimated 13% loss to the country's GDP. This massive damage happens with extreme speed. Rogue websites like Tamil Rockers and encrypted networks like Telegram frequently leak major film productions to the public within hours of their theatrical release. When someone steals a physical object, the owner loses possession of that object. But digital media presents an intangibility problem. When a movie is pirated, the studio still holds the original file, but because a perfect copy is available for free, the commercial value of that original is instantly destroyed. Since creative value is invisible and easily duplicated, it cannot be secured in a physical vault. Instead, it requires a specific set of legal protections to exist as marketable property in the real world. This comparison matrix breaks down the different forms of intellectual property. Patents protect functional inventions, and trademarks protect brand symbols. Copyright provides creators with the exclusive rights to reproduce, license, and monetize their original literary, musical, and artistic works. Under the Indian Copyright Act of 1957, legal protection is restricted to the tangible, fixed expression of an idea rather than the abstract idea itself. The function of this law is to draw an enforceable boundary between shared human inspiration and illegal financial appropriation. In 1978, the Indian Supreme Court decided R.G. Anand v. Deluxefields, creating the standard for how the justice system identifies creative theft. The court established the lay observer test. To prove infringement, a creator must show that an average viewer would look at both works and recognize unmistakable, substantial similarities in how the work was expressed. For example, a writer cannot legally own the broad concept of star-crossed lovers. However, they own the specific dialogue, character names, and scene sequences found in their individual script. By setting the boundary here, the courts ensure that universal themes remain in the public domain, allowing future artists to draw from common tropes without facing constant litigation. Looking at this timeline, copyright grants creators exclusive economic control over reproduction and distribution. In India, these financial rights generally last for the lifetime of the author, plus an additional 60 years. The 2005 case Amarnath Sehgal v. Union of India established moral rights as a separate category, one focused on protecting an author's reputation rather than their financial assets. Sehgal, a sculptor, sued after a bronze mural created for the government was damaged during removal. He won the case, proving that even after the physical art was sold, his right to protect the integrity of the work remained with him. Indian law treats a creative work as an inseparable extension of the creator's identity, recognizing their artistic interests long after a financial transaction is complete. These creator rights have specific legal limits. In 2016, several publishing houses sued a shop at the University of Delhi for reproducing excerpts of copyrighted academic books to create course packs for students. The courts ruled in favor of the university, citing fair dealing. This exception allows copyrighted material to be used without permission for specific purposes, such as education and research. This boundary proves that while the law protects a creator's right to monetize their work, it will restrict that monopoly to prioritize the public's right to access knowledge. The legal boundaries drawn for physical books and film reels are breaking down in the face of borderless digital data. This network map visualizes the modern enforcement challenge. Over a third of internet users in India utilize VPNs and proxy servers. These tools mask personal identities and route traffic through foreign servers, allowing users to circumvent traditional geographical laws. To counter this anonymity, rights holders use the IT Act. Under Section 69A, courts issue dynamic John Doe injunctions, which empower the government to force internet service providers to block public access to entire rogue websites. Today's courts are locked in an automated technological arms race with anonymous digital syndicates, a shift away from traditional disputes between individual authors. Now, copyright faces a new challenge: artificial intelligence. Machine learning algorithms can now generate massive volumes of art, music, and text in seconds. If copyright is designed to protect the human labor and reputation of an author, how does the law address content generated entirely by an algorithm? The current legal framework was built to protect human labor, but the speed of digital distribution and AI generation has created a gap that current copyright laws have yet to close.